Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
On the early evening of May 3, 2017, some 30 members of the Philippine Drug Enforcement Agency executed a search warrant at a suspected drug den in Quezon City. The search uncovered various drug paraphernalia, including 26 plastic sachets containing white crystalline substances, an improvised tutor, lighters, aluminum foil, and other items. The search led to the arrest of Lucky Enriquez. Laboratory tests confirmed the seized substances were methamphetamine hydrochloride, or more commonly known as shabu, but the accused Enriquez tested negative in the drug test. The Quezon City Regional Trial Court convicted Enriquez of illegal possession of dangerous drugs and paraphernalia, a ruling affirmed by the Court of Appeals. But on appeal, the Supreme Court acquitted him of the charges. His acquittal hinged on a flaw in the search warrant. It did not specify the location to be searched. Instead, it only said, Informal Settlers Compound, Nia Road, Barangay Piñahan, Quezon City. How crucial is the exact location of the premises to be searched? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 17th of January 2025. You're listening to the second part of our two-part episode on search warrants. Today, we discuss the case of People v. Lucky Enriquez, GR number 264473, August 7, 2024, penned by Senior Associate Justice Marvic MVF Leonen. And so we have with us again Professor Ted Te, who is the Chairperson of the Philippine Judicial Academy, Department of Humanitarian Law and Human Rights, and former Supreme Court Public Information Office Chief. Professor Te, welcome back to the podcast.
Thank you, Attorney Mike.
All right, so last week we were talking about how the judge should determine probable cause. In this week's episode, we'll talk about what should go into a search warrant in the context of the People versus Enriquez case. This is again a drugs case, which involves the issuance of a search warrant. But for the benefit of our listeners, what should go into a particular search warrant? What should be the contents of that?
As required by the Constitution against Section 2 of Article 3, the search warrant on its face must contain only one specific offense. It cannot contain more than one offense. It must contain a specific description of the objects to be seized, and the objects to be seized must have a connection to the offense that is stated. It must have a particular description of the place to be searched. The address itself must be given with specificity. If the address itself cannot be specified, meaning there is no house number, then a description that must be so particular that should leave no discretion on the part of the implementing officers must be given. In the situation where there are no units or no specific divisions, for example, of houses, or no house numbers, it can also include a sketch or a location map. Again, all of these are required so that the law enforcers who will implement the search warrant have no discretion in going to another place or taking any other objects. Then the judge must also certify that the warrant was issued only after a personal examination by the judge himself or herself of the applicant and any witnesses that the applicant may have presented. Those are the requirements of a search warrant that must appear on the face of the warrant itself.
Procedurally, Professor Ted, how long does it take for a court to issue a search warrant? And is there a validity period for the search warrant that's issued?
Well, the length of time before a court issues a search warrant really depends on the amount of evidence that the court must consider. If it is, for example, quite clear and therefore it is easy for the court to determine that there is no probable cause or there is probable cause, then it can take a matter of hours. But
Mm-hmm.
if, for example, there it is quite complicated and there are a lot of testimonies or other evidence that the judge must consider, then it may take more than that. But as to the duration of the search warrant is valid only for 10 days from
Mm-hmm.
date of its issuance. It
Mm-hmm.
cannot be extended, and the warrant automatically becomes void after the lapse of 10 days from its issuance. And
Mm-hmm.
so once the warrant is issued, law enforcers only have 10 days to carry out the warrant application. And here's a particular nuance there. While the warrant is effective for 10 days, once a search is already conducted within the 10-day effectivity period of the warrant, then the
Mm-hmm.
warrant automatically ceases to be effective,
Mm-hmm.
especially if there is a negative result.
Mm. All right. So what happens, Professor Te, if, for example, you indicated in the search warrant only these items to be seized, and yet there are other items that were found in the property? Should the law enforcers now go back to the judge and ask for an additional search warrant? Or can they seize that, even if it's not included in the search warrant?
Okay, if the law enforcers seize any other items that are not specified in the warrant, then those items, one, are not admissible for any purpose in any proceeding. It cannot be used at all because they have been illegally seized, and therefore they must be returned to
Mm-hmm.
the owner of those objects. The exception there is if the objects that were seized from the that are not included in the search warrant are contraband, in which case
Mm.
they cannot be returned. But
Right.
if they were not specified in the warrant, then they cannot be used for any purpose for any proceeding.
Mm-hmm.
Now there is a principle in search and seizure jurisprudence, the principle of evidence in plain sight or evidence
Mm-hmm.
in plain view. It's not an exception to a search warrant simply because an evidence in plain view requires that the law enforcement officers must have been lawfully present at the
Mm.
premises, meaning they must have a search warrant. They must have been there by virtue of a lawfully issued search warrant. And
Mm-hmm.
evidence in plain view would simply justify law enforcers taking contraband, taking
Mm-hmm.
illegal objects on site, even though they're not mentioned in the warrant, simply
Mm-hmm.
because it already indicates that a crime is being committed.
Right. Mm-hmm.
But the evidence in plain view principle requires that the law enforcers must not conduct a search, meaning it must literally be in plain view. So, if, for
Mm-hmm.
example, the officers are in the premises by virtue of a warrant where they are looking, for example, for a particular firearm,
Mm-hmm.
where the firearm is described in the warrant. And so they're not supposed to be looking for any other thing.
Mm-hmm.
But while they're searching the premises, let's say they encounter a large cache of firearms,
Mm-hmm.
high powered, which probably are not licensed, right?
Mm-hmm.
Should they then, as you say, go back to the judge and say, get another warrant? If
Mm-hmm.
those firearms are not licensed, then that's evidence in plain sight. And
Mm-hmm.
so therefore they can seize those objects, because there's evidence in plain view. If it is in plain view.
Mm-hmm.
Now, if the firearms are, for example, hidden, they're in a closet, and they opened the closet and they saw those firearms, then that's not evidence in plain view.
Mm.
Then those objects would then be subject of an illegal search if they actually take those objects, right?
Mhm.
And so, therefore, in that situation, what should law enforcers do? They must then apply for another warrant because they
Mhm.
now have probable cause that there is another, set of firearms that are probably unlicensed. Go to a judge and then say, we want to go back to this place and seize those objects. That is so that the objects seized in the cabinet would then
Mhm.
be admissible. Because if they seize them, evidence in plain view supposedly, but it's not it's not in plain view because they had to search. They had to
Mhm.
open a cabinet. That would be subject definitely of a motion to suppress.
Mhm.
And therefore, and under jurisprudence, clearly, and under the Constitution, it would probably be declared as the fruit of the poisonous tree. It would be
Mhm.
declared inadmissible. So if the police really wanted, for example, to seize those objects because they're probably unlicensed, they're probably illegally possessed, then they should then apply for another warrant.
Mhm.
The original warrant would not contain those objects. That
Mhm.
would there would clearly be no probable cause to seize those objects.
In the meantime, Professor Te, what can law enforcers do? Can they padlock the property, secure the property so that other items that they want to seize will still be there
They
when
can
they
probably
want to
just
do that?
secure the property while waiting for a warrant. But of
Mhm.
course, they should respect the rights of the occupant because the occupant, of course, has certain rights still, even though the warrant has already been served. But
Mhm.
while that's done, then they can just simply go back to the judge, secure the property, go back to the judge, and get another warrant or have
Mhm.
the warrant amended.
At which point, Professor Te, the court decide that this is a fishing expedition if there are too many items that were seized without a search warrant? Or can they just simply brush off the other evidence as inadmissible because they were fruits of a poisonous tree?
Again, it depends on what law enforcers would do. If the law
Mhm.
enforcers would seize those guns, for example, remember in the hypothetical we gave, they were there because of a lawful search
Right.
warrant to seize a particular firearm. They had probable cause to seize the particular firearm connected to the specific crime mentioned in the warrant. They were
Mhm.
not looking for firearms illegally possessed, subject of an illegal possession of firearms charge. But when they get to the place, they open a cabinet, they see guns, probably unlicensed. If they check with the FEO, they will probably see it's unlicensed. So
Mhm.
if they seize those firearms immediately, then that's probably going to be subject of a motion to suppress, fruit
Mhm.
of the poisonous tree. They would probably be excluded, declared inadmissible. But if they wait for some time, they go to a judge and say, Judge, we now have proof that there are illegally possessed firearms in the same
Mhm.
premises. Here's a witness. Here are photos, etc., etc., etc. Can we now get another search warrant
Mhm.
to get those firearms? Then probably yes, they can do
Mhm.
that. Now, there is an exception, only one exception to the search warrant requirement under Rule
Mhm.
126. And this is what we call a search incident to a lawful arrest.
Mhm.
Now, that particular exception, being an exception, is very narrowly read, right?
Mhm.
The exception states that there must have been first a lawful arrest.
Right.
And because it needs a lawful arrest, whether with a warrant or without a warrant under Rule 113,
Mhm.
once there is a lawful arrest, meaning there is basis for that arrest, a search can then be conducted, right? And
Mhm.
so that search can be an immediate search, let's say, of the person, the body of the person. Because if the person is arrested in flagrante, for example, by the law enforcer, that law enforcer can pat down the person
Mhm.
to check for dangerous weapons, even for fruits of any offense.
Mhm.
That law enforcer can also look around the immediate vicinity of that person
Mhm.
and how far can that person can warrantless search in that situation extend. It can extend to a location that would probably reasonably be construed as far enough where the person can dispose of any objects.
Mhm.
You know, always a practical matter, because the objective of allowing that search incident to a lawful arrest is to prevent that person who is arrested from disposing of evidence. So
Mhm.
what's the test? Maybe as far as the person can throw, right?
Mhm.
Or can drop the object. Now,
Mhm.
can they arrest the person and then bring that person to his house and then
Mhm.
search the house? No,
Right. Mm.
no. If the house, for example, is far away, that there's already case law to that effect, Lasco versus
Mhm.
Panyo. And therefore, if the person is arrested in his residence, right? Can the police, for example, go to all the rooms in that residence on the basis of a search incident to a lawful arrest? Still no, because
Mhm.
then it would be an unlawful search, right?
Mhm.
Because they were there to serve a warrant of arrest. What they're concerned about simply is concealment, disposition of evidence, or
Mhm.
if there are weapons on the person, on the body of the person. But
Mhm.
it does not justify, for example, going up to the second floor of the
Right.
house, going to the room of the person, going to other parts of the house where the person was not found, right? And so that's an exception. So I think those would be the parameters of a search in this case.
Hmm. And let me go back to the case of People versus Enriquez, because you
Mm,
mentioned the specific site that to be searched. In this case, the search was for a particular, I think they just mentioned informal settlers in a certain area. And we know in Zafe, if you just mention the barangay, that's not enough. So how
mm.
much more in this case, informal settlers area? How important is it that the search warrant should specify the area to be searched? Is there a requirement that the house number should be indicated? A description of the house should be indicated? What's the logic behind this requirement?
Okay, so here the search specified inside the house, the subject house, and then it says, please see the map, right, of
Mm-hmm.
the house. Located at Informal Settlers Compound, near Road,
Mm-hmm.
Barangay Pinahan, Quezon City. Okay. Now, the court ruled here in the Lucky Enriquez case that the wording of the search warrant fails to meet the particularity requirement because it gave the law enforcers free rein to search every place within that compound. No,
Mm-hmm.
uh, and the court also mentioned, took note that the sketch that was attached to the search warrant, no, uh, could not allow the law enforcers to distinguish the place to be searched, no, because the particular map, no, was not clear enough, no, was not clear
Mm-hmm.
enough, and therefore the map itself also the court found was not even part of the records. It was not clear if it was part of the records, and therefore
Mm-hmm.
it could not validate, for example, the search. No, the court had doubts about whether the map itself was actually there. No,
Mm-hmm.
and therefore the court said that rendered the search warrant and its description defective. No, and
Mm-hmm.
so the court said that that's not sufficient. We cannot allow
Would
that.
would the presence of the map have cured that defect? Can the search warrant just say, please refer to the map? Is that enough?
The map itself must be particular. Again,
Mm.
what we're looking for here is that the law enforcers should not be allowed to speculate or guess. No, so
Mm-hmm.
if for example a sketch map were provided and the sketch map only has blocks,
Mm-hmm.
X number of houses, and then an arrow. It does not indicate how to distinguish one house from another,
Yes.
especially, for example, in the context of the Enriquez case, where the description was within the informal settlers compound.
Mm-hmm.
And so, if there was no particular way to distinguish one house from another in the map itself, then I think that map would also be insufficient to meet the
Mm-hmm.
particularity requirement. So, what we're looking for here is that any description of the place must be so particular that the law enforcers do not need to guess. They just need to recognize the particular house. If a house number is not present, a description of the house, describe the gate, describe the houses beside it, for example, so that there is no mistaking the particular house. If, for example, it is a row of apartments and there is, let's say, just one number in that apartment, right? It must be so particular that the location of the apartment, which apartment are we looking for? If there
Mm-hmm.
it's a row of 5 apartments, is it the second apartment? Is it the fourth apartment? It must be so particular that, again, the police cannot be allowed to guess which
Mm-hmm.
particular house. They should not be allowed to use their discretion in determining it may be this house, because even if they get it right, then it only indicates that there was lack of probable cause in the first
Mm-hmm.
place, because probable cause cannot be determined if there is no particular description of the house,
Mm-hmm.
because
If
then
I
the
if it
court cannot be satisfied that That's supposed to be the place to be searched.
And in fact, in this case, Professor Te, the court took it against the law enforcers that they needed the assistance of a confidential informant in determining the house. So that means
Yes.
when you have the description, it should be clear in itself. It should not require any assistance from any person in determining
Yes.
where the house is.
Yes. In this case, for example, if they had information from this so-called confidential informant,
Mm-hmm.
then that confidential informant should be able to give them sufficient information and to give the judge sufficient information as to where the house is located. If the judge could not, based on the testimony, presumably of the confidential informant, before the judge, if the information could not satisfy the judge that there was a particular description of the house such that the location could be ascertained without the assistance of the confidential informant in looking for the house, then there should have been no probable cause determined. So
Mm-hmm.
effectively here, when the prosecution, then the law enforcers were using the confidential informant to look for the house, no, it actually already indicated that there was no probable cause for the
Mm-hmm.
issuance of the search warrant.
Mm-hmm. And let me go now, Professor Te, to how a search warrant must be implemented. Is there a particular requirement under the rules as to how the law enforcers should implement this? Because there are many cases where the law enforcers will just barge in, get
Mm.
inside the house, arrest the person before conducting the search. How should it be implemented?
In the first place, the search warrant must be presented. Okay. That's again one difference between a search warrant and an arrest warrant. In the case of a search warrant, before entry into any premises, the authority to enter must be declared, meaning the law enforcers must say, we have a search warrant for this particular premises. Here is a copy of the search warrant. The search warrant must be presented, it must be shown, and the occupant must be given the opportunity to inspect the search warrant to determine whether the search warrant is in fact sufficient on its face because the address must be given.
Mm,
And for example, if the occupant will say, well, that's the wrong address, this is a different number, then
mm,
it must stop there. The law enforcers cannot insist and say, no, this is the right location, even if it is stated already and it is manifest that it is the wrong address. So the search warrant must be presented. Unlike an
mm,
arrest warrant, if an
mm,
arrest warrant is issued by the court, when the arrest is made of the person, the arrest warrant need not be presented for practicality reasons because an arrest by virtue of a warrant can be made anywhere where the person is found. It is
yes.
not necessarily in the place where he lives
Mm-hmm.
or it's anywhere where the person is found. And so it would be impractical for every law enforcer in every part of the Philippines to have a copy of every warrant issued.
Mm-hmm.
That's thousands, tens of thousands of warrants.
Right.
So it would be impractical. All that the law enforcer needs to do when the enforcer is arresting someone by virtue of a warrant is to inform the person of the authority for the arrest, that I am arresting you by virtue of a warrant issued by the court. And at the earliest opportunity, that warrant, the copy of the warrant must be shown to the arrested
Mm-hmm.
person. But going back to a search warrant, before entry is made, that search warrant must be shown.
Mm-hmm.
And upon entry, then the only thing again that the enforcers should be doing is to look for the specific objects in the warrant within the place and
Mm-hmm.
no other. Once the search is conducted, right, if anything is seized, then the law enforcers must fully document what was seized. They must
Mm-hmm.
issue a receipt, and that receipt must indicate what was taken by virtue
Mm-hmm.
of the search, if anything was taken. If nothing was taken, then it must also indicate that.
Mm-hmm.
That receipt must be given to the occupant of the house.
Mm-hmm.
And before any search can be done, it must be done in the presence of two witnesses. That is a
Right.
requirement under Section 8 of the rules.
Mm-hmm.
And these two witnesses must be identified by virtue of, again, a hierarchy. No?
Mm.
The two witnesses must be of sufficient age and discretion residing in the same locality as the person.
Mm.
No? And the only time the two witnesses would be called in is if the lawful occupant of the premises is not present, is
Mhm.
unavailable, or any member of the family of the lawful occupant is not
Mhm.
present or is not available.
Mm.
If the lawful occupant is present, then the law enforcers cannot insist and say, please depart the premises because we have two witnesses.
Mhm.
The wording of Section 8 says, if the lawful occupant or the member of the family are absent, two witnesses of sufficient age and discretion residing in the same locality. Okay?
Mhm.
So that's in order to protect the right of the lawful occupant to anything that may happen during the search. No? So that would be the procedure by which a search is to be conducted by virtue of a search warrant that is lawfully issued.
Mhm. There were two issues here in respect to the
Mm.
implementation of search warrants. One, um, the fact that they were not given permission to come in; they just barge
Yes.
in, and that calls into question when can law enforcers invoke the right to break entry into a premises. And second one, apparently, the accused, Mr. Enriquez, was not around when the search was conducted.
Mm.
How significant were these two issues in the resolution of this case?
Well, they were quite significant because the court actually disagreed, no, with the position of the law enforcers here and the prosecution here. No? The court noted that Rule 126, Section 7 of the Rules of Court actually gives the rule, no, for breaking open any door or window, which is mentioned in Section 7. No?
Mm.
It requires that there must have been what the court describes as preliminary acts that must be
Mhm.
accomplished before the right to break open doors or windows is triggered. The court said this would provide a so-called roadmap that
Mhm.
agents must follow. First, they must announce, no? They must give notice of their purpose and authority for entering, meaning we have a search warrant and this is the search warrant. And then they must request admittance to the place to be searched.
Mhm.
And these preliminary acts, no, uh, must be done before unannounced intrusion may be justified. And the
Mhm.
court here said that they did not do that here. They did not comply with that here. And so the unannounced intrusion, no, was not justified here. And so because of that, the court said that the manner by which the search warrant was implemented here was defective.
Mhm. And the second aspect, Professor Te, was the fact that he was not there. So
He
he
was
was
not there, yes.
present, but he was not present during the search. And there are many instances where there was already an arrest made before a search was conducted. And obviously, because when the accused was already arrested, he could not observe the search as it
Right. That's right. And so, again, as mentioned earlier, that the general rule is that it must be done in the presence of the lawful occupant or a member of the
happened.
family, because the presumption there is that this would, of course, the interest of the lawful occupant would be safeguarded by the members of his or her family. It is
Mhm.
only when they are absent that the two witnesses would come in. And
Mhm.
here the court mentioned the hierarchy of who are prioritized as witnesses, right? And it says first the lawful occupant, no? And then any member of the family. And it is only in their absence that the individuals of sufficient age and discretion residing in the same locality may come in as witnesses, no? And therefore the court said if that is not followed, then again the search, no, is defective, even though the warrant may in fact be lawful. But the court also said the warrant here was also problematic.
Mhm. Mhm. And the consequence, Professor Te, of improperly implementing a search warrant, does it necessarily lead to the dismissal of the case?
In this case, the court acquitted the accused, no?
Mhm.
Again, because the court held that the search that was conducted in this case was implemented in violation of the accused's right under the Constitution and the rules of court, no? And therefore, the search was declared void, no? And the
Mhm.
items seized from the search are inadmissible as evidence for any purpose in any proceeding, may not be used against the accused in relation to the accused's conviction in the present case, no? Because the accused here had already been convicted. And therefore, the court acquitted the accused, no? Reversed the judgment of conviction, set it aside because the search was improper, it was void. The objects seized were declared inadmissible under the principle of the fruit of the poisonous tree. And because of that, the court said that since there would be no other evidence to support the conviction, then the conviction cannot stand and he must therefore be acquitted.
And on that note, thank you so much, Professor Te, for this very enlightening discussion about search warrants. So this is like Search Warrants 101 in 2 episodes of our podcast. Thank you so much for joining us.
You're welcome. My pleasure, Mike.
All right. And if you wish to read the full text of the decision we discussed today, you can go to the Supreme Court website and e-library and search for People versus Lucky Enriquez, GR number 264473, August 7, 2024. Here's Steph Atendido Beltran, Supreme Court Information Officer for this week's Roundup.
At the Supreme Court this week, Chief Justice Alexander G. Hismundo administered the oath of office to newly appointed Sandiganbayang Presiding Justice Geraldine Faith A. Ekong on January 13, 2025, at the Supreme Court en banc Session Hall. Prior to her recent appointment, P.J. Ekong served as an Associate Justice of the Anti-Graft Court for almost 9 years. P.J. Ekong succeeds Sandiganbayan P.J. Amparo M. Kabatahetang, who retired on November 7 last year. The Supreme Court en banc on Tuesday, January 14, issued temporary restraining orders or TROs involving 5 candidates running in the 2025 elections. The High Court prohibited the Commission on Elections, or COMELEC, from declaring Subair Guintum Mustafa, who is running for senator, and Charles Savellano, who is running for 1st District Representative of Ilocos Sur, as nuisance candidates. The Supreme Court also stopped COMELEC from rejecting the application of Chito Bulatao Balintay, a member of the indigenous peoples of Zambales, which prevented him from filing his certificate of candidacy for Zambales governor. The Supreme Court also issued TROs prohibiting the COMELEC from disqualifying Edgar R. Erice as candidate for representative of the 2nd District of Caloocan and from canceling the certificate of candidacy of Florendo de Ramos Renren Retualo Jr. for Sangguniang Panglungsod member of San Juan City's 1st District. Meanwhile, the Supreme Court has affirmed the conviction of a man who pretended to be a lawyer by using the identity of a deceased attorney. In a decision penned by Associate Justice Samuel H. Garlan, the SC's 3rd Division found Pedro Nolyora Pequero guilty of the crimes of use of illegal alias and use of fictitious name. In 2011, Pequero was arrested in the Binangonan Municipal Trial Court during an entrapment operation by the National Bureau of Investigation, or the NBI, following a complaint that Pequero was pretending to be a lawyer by signing pleadings and appearing before courts using the name Attorney Epafrodito Nolyora. Records from the Office of the Bar Confident show that there is only one Attorney Epafrodito Nolyora who died on May 19, 1986. The Supreme Court held that Section 1 of the Anti-Alias Law prohibits the use of a name that does not correspond to your real name, unless it is for specific purposes, such as stage names, screen names, pen names, and others for literary, cinema, television, radio, or entertainment purposes and at sporting events. The court added that Article 178 of the Revised Penal Code punishes people who use a fake name to cause harm. In Pequero's case, the court found that he caused significant harm to the public, especially his clients, by impersonating Attorney Nolyora. Today, January 17, 2025, is the last day for the successful 2024 bar examinees to complete the clearance procedure via the Bar Applicant Registration Information System and Tech Assistance, or BARISTA. The Office of the 2024 Bar Chairperson, Supreme Court Associate Justice Mario V. Lopez, and the Office of the Bar Confident reminded all successful bar examinees that requests for extensions shall no longer be accommodated and that failure to complete the clearance procedure shall render a successful bar examinee ineligible to participate in the oath-taking and roll-signing ceremonies on January 24, 2025 at the SMX Convention Center, Manila in Pasay City. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast episode this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, Don Ryan Balza and Victor Laranio as sound editors, and Tyke Flores and Jerome Batumalake as web editors.